I just want to give you an update on the PAC initiative, which is now been certified as proposition number 46 on the November ballot. This is an initiative to raise the pain and suffering damages, the non-economic damages that can be recovered by those who have been injured by healthcare providers. At present, you can collect only $250,000 for your injury or the injury of a loved one, even death in a medical malpractice or a hospital malpractice case. This law was passed back in 1975, and there was no cost of living adjustments factored in. It has been determined that if cost of living adjustments were made over the years, that $250,000 would equal over $1 million in pain and suffering damages at the present time. And that is what Proposition 46 requests, that there be a change simply to bring the damages up into the present age, because in 1975 dollars, it's only $57,000, which isn't much for any compensation. It's basically unfair. There are no other such limits in any other type of injury, such as in a car accident or a slip and fall. The initial poll in this proposition is 71% of the registered voters are in favor of the initiative, but that was a poll that was done in May. The backers of the initiative only have $2 or $3 million so far to work with to try to get the message out to the public, whereas the medical lobby and the insurance lobby on the other side is going to have tens of millions of dollars to put out disinformation. They are already gearing up to make an argument to the public, which is highly misleading. Their argument is twofold, that you will be denied medical care because the costs of doctors treating you will be so high that it will be prohibitive for doctors to provide any treatment or care to people. This is completely false, and it's been shown in other states, specifically in Florida, that the cost did not appreciably go up. Second of all, they say that it will cause frivolous or baseless lawsuits to be filed that will only benefit attorneys. There are no attorneys that I know of that would take a case that is frivolous or baseless and invest tens of thousands, if not hundreds of thousands of dollars into the case unless the case had merit. And if we're saying that this will drive up costs based upon meritless cases, these cases go to jury trial, and it's 12 people that are picked from the general public who make decisions, and they're not going to get fooled by a case that has no merit. So the only cases where you find large verdicts against healthcare providers is where there is strong evidence that they have been guilty of negligence and that the damages are meritorious and are reasonable. Initiative also not only raises the limits for pain and suffering damages to what they would have been if a cost of living factor was factored in back in 1975, but also it will hold doctors accountable who are prescribing drugs that are either unnecessary or writing out multiple prescriptions for the same person, or not verifying that that person has been getting prescriptions from other people, other doctors. In fact, there have been many cases lately in the news about doctors who write prescriptions after speaking to somebody for only 2 or 3 minutes and not really examining them, and then you find out that this person is an addict, or they've gotten prescriptions from 2 or 3 other doctors, or they're getting the pain medication and selling them on the black market. This initiative would require healthcare providers to verify that there aren't multiple prescriptions out there for the same person. Also, it would require drug testing for doctors and other healthcare providers. In many other fields in which the public safety is paramount, such as with police officers, firemen, people who do long-term trucking, they're required to give urine samples periodically to determine whether or not they have been using drugs that would impair them in any way. So I don't see how an initiative that would require doctors or other healthcare providers to do the same would in any way affect their ability to practice. In fact, it would weed out the doctors who are addicts, and it would help assure that the public who has seen a doctor who is sober and not someone who doesn't know what they're doing. The other thing that the initiative would help to do would be to make sure that doctors report other doctors who are negligent, and that we won't have this veil of silence that tends to allow the doctors to turn a blind eye to doctors that are performing their duties negligently. I have had many clients who come in and tell me that they've had second opinions from doctors, and the doctor has told them that they believe that their first treating doctor was practicing below the standard in the community, but when it comes time to take their deposition, they won't testify to that because they don't want to testify against another doctor. If the law would require them to come forward if there is negligence they know of, then this would stop this, and it would help to safeguard the public. So as the summer goes on and the fall goes on, I will be updating you on any further developments, and whether the initiative seems like it's going to pass, or whether the consumers in California will be again denied their basic rights.